So we'll go to our next speaker, Roberta Nunin from the University of Trieste. Roberta is Associate Professor of Labor Law at the University of Trieste. She teaches European labor law and she is Director of the Master Course in the Labor Law and Social Security of the same university. Her fields of studies, her interests are in particular in European social dialogue, freedom of workers movement, labor law and parenthood, labor law and discrimination, child work, protection of health and safety at work, atypical work, young people and labor market, gender pay gap, and recent trends in collective bargaining. So, Roberta, please.
Thank you very much. It's an honor for me to be here in this very important workshop that also testifying the friendship between the University of Trieste and the University of Ljubljana. So, in the post-war changes following the end of the Second World War, looking at the dynamics of women's work in Italy, a crucial role was played by the very difficult and slow process of transition from the regulation of women's work by the fascist legislation to the full implementation of the constitutional principle affirmed by Article 3 and specifically by Article 37 of the Italian Constitution, which entered into force on the 1st of January 1948. During the fascist period, the approach to the question of female labor was in Italy substantially expulsive, albeit hidden behind an ostensible protective intent. For the regime, women had an essential task, which towered all the others, to procreate generation of soldiers for their homeland, of course, and also for the empire's wars which were prepared, and also to watch over the integrity of the family. So the Italian women saw themselves forced by the ideology of the regime within the boundaries of the family, as mothers of prolific, and this was the place of construction of their identity, flattened on motherhood and the family fence, which consecrated the subordinated role of the women in the Italian society at the time. However, the fascist policy also loaded on the women's shoulders some very important goals of the regime: the demographic expansion, object of many obsessive propaganda campaigns by the regime, and also the conservation of the social peace, by one side through the employment policies that found in the expulsion of women from many working contexts, industrial but also in public services, that they had occupied since the First World War. Here was found the lever to struggle against the male unemployment in Italy in the first. And by the other side, also through the unpaid work done for the family as an essential contribution in a situation of lack of many social services. Furthermore, this approach is also allowed male workers substantially deprived of rights at workplaces at the time to recover a kind of archaic authority to exercise within the enclosure of the family towards women also legally subjected to them. In Italy, for having the reform of the family law, we had to wait until the year 1975, as was said before. Furthermore, the demographic campaign was not unwelcome to the Catholic Church, largely recovering the more traditional Catholic thought reiterated in the year 1930 by Pius XI with the encyclical Castico Nubi, thus being able to anchor the most brutally anti-feminist statement of the fascist regime to the Catholic ideology of women and family. Having necessary to summarize, we could say that the fascist solution to the female question sees from the legal point of view, three fundamental steps. The mass organization of women through the so-called fasci femminili, the creation of some very basic welfare institutions, however later very discussed by scholars, in particular the references to the ONMI, the Opera Nazionale Maternità Infanzia, the Organization for Motherhood and Children, and a specific legislation on family, of course, and on work, women's work too. Limiting ourselves here to this last profile, it must be remembered that Fassin's intervention on female work was very numerous, with a lot of laws and norms presented as protective. For example, the well-known law on children and female work of the year 1925, and the law of the year 1934 on working mothers, but clearly inspired by the need for protection of the lineage. The working woman as such was not protected, but which was protected was her ability to generate children for homeland and in perspective for regimes worse. Even more numerous were the intervention, the laws that decreed the expulsion of women from many working contexts, to protect them, of course. By the law of the year 1934, in fact, a very important series of restrictions on female employment were introduced by law. But even earlier, in the reform of scholar system of the 20s in Italy, the fascist legislators, stating the lack of the prerequisite of women of a virile attitude and vision of life, necessary to direct high school and to teach some key subjects such as history, philosophy, Italian, Latin, Greek, with two royal decrees of the year 1923 and 1926, excluded women from competition for teaching in the 4th and 5th classes of technical institutes and the high school classes, as well as from the roles of principals. From the year 1928, preference was given in recruiting for public offices to male heads of family. During the years after the post-29 crisis, the recruitment of women in all public competition was limited with the possibility of excluding it at all. Finally, with the law decree of the year 1938, a maximum share of 10% of women was imposed in medium and large public and private companies, and claims to exclude them completely in offices or businesses with less than 10 employees. Moreover, the previous protective legislation and occupational segregation had already pushed Italian women well below this threshold in many contexts. In any case, there was an important wage gap, it was said before. For the same job, female wages were significantly lower, and the female presence in the informal, submerged, and unprotected economy grew very much during all the 30s, with particular regard to domestic work, but not only. In 1940, however, with the outbreak of the war, there was an obvious surge in women's work. On the 5th of June 1940, the regime removed all limits to the use of female labor, but the working conditions, especially regarding wages, remained wildly worse and discriminatory. Then, the massive presence of women in the strikes against the regime from the end of 1943, and also the important presence in the resistance struggle and otherwise, has strongly emerged the female component in the political scene. Certainly, participation in the resistance movement had created the objective and subjective conditions for the regulatory change in terms of emancipation. Sorry for this not short introduction, but it has been necessary to evaluate which was the impact of the new constitutional rules in the transition phase, which in the labor law perspective certainly lasts until the end of the 60s. Despite the clear indication of the Italian constitutional charter, in fact, in the immediate post-war period and throughout the 50s, The legal and structural conditions that hinder the true path of equality of Italian workers and working women remain very strong. The cultural heritage of the fascist policies on the question of female employment, with a restrictive and disincentivating discipline which, among other things, equated the work of adult women with that of children, bringing together both these groups in the pay discrimination linked to the identification of them as health forces, continued for a long time during all the 50s to condition viscously the approach to the question, also for most of the jurisprudence of the time, whose exponent had studied and began to work and been training largely during the fascist 20s. The Constitutional Charter and its Article 37, of course, an epochal turning point, aimed at liquidating the role that had hitherto influenced the history of women's work in our country. Italian women so, in fact, finally recognized the equality at work, not only on a formal level, but also on the substantial one, which until then had always been denied them, with the affirmation of full equality of treatment. The Constitution has decided to sanction a system change. And it is important to remember the role played by the only 21 female deputies to the Constituent Assembly on a total of 556, and among them the only 5 women, Teresa Noce and Nilda Iotti for the Communist Party, Lina Merlin for the Socialist Party, and Angela Bottelli and Maria Federici for the Christian Democratic Party, who were a part very important of the so-called Commission of 75 in charge of drawing up the draft constitution to be submitted to the Constituent Assembly. Combining the equality of right and a specific protection to be tied necessarily to the physiological moment of motherhood was the arduous task of the Constituents, which involved a very long and complex discussions from a legal point of view, and finally gave shape to a formulation divided into 2 parts. The result of the compromise was said before this, in which the affirmation of the full equality is further enhanced by the recognition of the special adequate protection to be guaranteed to the mother to allow her to fulfill her essential family function. Here is plain the compromise between the position of the left parties and also of the trade unions itself of the period, which posed the change in the legal status of women as an essential moment for the full insertion into the political and social life of the country, and the conservative position of the Christian Democratic Party bound to a conception of a role, domestic and family-linked, of women, typical of the Catholic tradition. It should not be forgotten that the Pope Pius XII, in October 1945, reiterated that the destiny of the women, Italian women, was that of being a mother, expressing at the same time a clear disadvantage for external work. A woman who will go to work, wrote the Pope, stordita dal mondo agitato in cui vive, abbagliata dall'orpello del falso lusso, diventa avida di loschi piaceri. Confused by the world where she is living, is confused also from the fake luxury, and she can be a victim of very bad pleasures. This can be a translation. Moreover, even on the communist side, it is interesting to note that there was no radical critique of the structure and function of the family, and indeed the centrality of the social formation was reaffirmed, however recovering it as a privileged value for the development of female personality. This is the ground on which Article 37 of the Constitution, marked by the contradiction between the unanimous desire for reform and the political opposition to the context of the reform, was adopted. But the uncertainties not of little importance present also in the life of parties of the time on the balance between right to work and domestic role of women. Finally, by the persistence of de facto condition of inferiority of women's work, which continued to manifest themselves even after the entry into force of Article 37, and that in fact were not affected by the contractual initiative of trade unions of the time. Particularly significant is the issue of equal pay, still relevant today, which occupied an important part in the debate of the Constituent Assembly. Indeed, there was no shortage of proposals aimed at including in the constitutional text the reference to the same performance as a parameter of equal pay. These proposals were, however, rejected, but upon approval of Article 47, it was pointed out by some that in any case, the concept of same performance had to be considered implicit in the concept of equal work. This interpretative approach didn't fail to make its pernicious effect felt throughout the 50s, and on this profile, I want to focus some last remarks. The equal pay question, in fact, represented in Italy through the 50s almost the only objective of trade union section in terms of action for women's work. Analysis of factory working conditions revealed the widespread existence of wage discrimination against women based precisely on the lower performance, and also linked to a segregated professional classification of women, which involved attributing to them the worst remuneration parameters. Even the Agreement on Wage Equality of the year 1960 failed to resolve this issue, since women were, as a rule, however, placed in the lower categories. Female labor, therefore, continued to be attributed a lower value than that of the male. At the time, to justify this discrimination, there were two dominant arguments: the poor professional qualification of the female workforce and the lower performance, mainly due to the lower availability in the workplace and the greater absences related to the care work for the family. Finally, in fact, the classification scheme was based on the existing division of labor, which saw women losers as they were considered less qualified and productive. This approach, which in fact weakened the constitutional principle as hindered their implementation, was confirmed throughout the 50s also in the approach of jurisprudence. At first, the majority of judges oriented themselves to consider the provision of Article 47 on equal treatment only programmatic and not perceptive, in perfect coherence, moreover, with the strongly conservative guidelines of the Italian governance of the time. Many decisions, I do not mention them. A first turning point was with the judgment of a Court of Appeal of Milan of June 1955, which recognized the dialectic, perceptive, and not only merely programmatic nature of Article 47. Then we had numerous judgments in this side of the Court of Cassation. And the Constitutional Court, to close, there are no intervention in the first half of the 50s, as the same began to operate in Italy only in 1956. Then there was a very long and important path in which the Constitutional Court played a fundamental role in the affirmation of principles aimed at tackling gender discrimination against working women. For example, with one of the first decisions, the sentence number 33 of the year 1960, the Court recognized the illegitimacy of the rule contained in a law of the 1919, which prevented women from accessing to main public careers and public offices. In 1963, as a result, a law opened in Italy the access for women to all public high careers, including judiciary one. But remember also that, for example, we had to wait until 1977 to see the first comprehensive law devoted to struggle gender discrimination in the workplace. And just for a few weeks, the Italian Constitutional Court has seen, for the first time in its history, a female president, Professor Marta Cartaglia. But here, we are well beyond the transition period covered by this conference, and therefore I stop here. Thank you very much for your attention.